Good morning and welcome to this Fairfax County Board of Building and Fire Code Appeals hearing. Today is Wednesday, September 8, 2021. My name is Carla Guerra Moran and I am the secretary to this board. Before I turn this over to our chairman, Mr. David Conover, I will go over a few guidelines for this hearing. First, the hearing is being recorded and the recording will be available on our website after the hearing. Second, please identify yourself by first and last name each time you speak. Third, if you have any difficulties during the hearing, please email me and I will try to assist you and let the chairman know. My email address is carla.guerra-moran@fairfaxcounty.gov. That is carla.guerra-moran@fairfaxcounty.gov. I will now turn this over to the chairman of the Fairfax County Board of Building and Fire Code Appeals. Mr. Conover, the floor is yours.
Thanks, Carla. Good morning, everyone. And thanks to staff at Land Development Services for your efforts in setting up this hearing. For the record, it's 10:02 a.m. on Wednesday, September 8th, 2021. I'd like to open the September meeting of the Fairfax County Board of Building and Fire Code Appeals, otherwise known as the board, at which we will conduct a hearing on an appeal scheduled to be heard at this meeting. To conduct this meeting and hearing wholly electronically and to effectuate both the emergency procedures authorized by FOIA and the emergency ordinance, the board needs to make certain findings and determinations for the record to address appeals that have been filed with the building, property maintenance, or fire official in a timely manner. Conducting this hearing wholly electronically will be a bit challenging, so I ask you in advance for your patience. Because each member of the board is participating in this meeting from a separate location, we must verify that a quorum of members is participating and that each member's voice is clear, audible, and at an appropriate volume for all of the other members. Accordingly, I'm going to conduct a roll call, ask each board member participating to state their name and location from which they're participating, and I would ask each board member to pay close attention to make sure you can hear each of your colleagues. Following this roll call, we will vote to establish that every member can hear every other member. So I'm going to do a roll call based on the names that I see. George Page.
Yeah, this is George. I'm here at my home in Herndon.
Mike Grinnell.
Mike Grinnell from Springfield.
Rob Fisher.
This is Rob Fisher. I'm at my office in Vienna.
Thank you. Amado Fernandez.
Yes, Amado Fernandez. I'm in my home in Chantilly.
Thank you. Good morning, gentlemen. I'm Dave Conover. I'm calling from my home in Great Falls. And I looked at the list. Are there other board members on the call?
Yeah, Wayne Bryan from my home in Vienna.
Thanks, Wayne. Sorry, I should have moved my cursor down further. Now I see you. I need to get a bigger screen or smaller print. Okay, I move that each member's voice, I'm passing the role of chairman at this point to, I'll ask George Page to serve as chairman momentarily so I can make a few motions. I move that each member's voice may be adequately heard by each other member of the board. I'd ask for a second and then we'll vote.
Second, Mike Grinnell.
Okay, all those in favor?
Aye.
Anybody opposed? Having established that each member's voice may be heard by every other member, we must next establish the nature of the emergency that compels these emergency procedures. The fact that we're meeting electronically, what type of electronic communication is being used, and how we have arranged for public access, including appellants and appellees on our agenda this meeting. Again, I'm going to pass the roll to George Page, and I will move that the state of emergency caused by the COVID-19 pandemic makes it unsafe for the board to physically assemble and unsafe for the public to physically attend any such meeting. and that as such, FOIA's usual procedures, which require the physical assembly of the board and the physical presence of the public and appellants and appellees, cannot be implemented safely or practically. I further move that the board may conduct this meeting electronically through a dedicated audio-video conferencing line, and that the public may access this meeting by calling 1-571-429-5982 and entering access code 42710449#. I ask for a second on the motion, and then we'll vote. Is there a second?
Second, Mike Grinnell.
Thanks, Mike. All those in favor?
Aye.
Aye.
Any opposed? I can't wait till we get to meet face to face again. It is next required that all the matters addressed on today's agenda must address the emergency itself, are necessary for continuity in Fairfax government, and are statutorily required or necessary to continue operations in the discharge of the board's lawful purposes, duties, and responsibilities. Again, I'm going to pass the role of chairman to George Page and move that the matters addressed on today's agenda must address the emergency itself, are necessary for continuity in Fairfax government, and or are statutorily required or necessary to continue operations and the discharge of the board's lawful purposes, duties, and responsibilities. Is there a second to that motion?
Second, Mike Grinnell.
Thanks, Mike. All those in favor?
Aye.
Aye.
Anybody opposed? That's passed. We have one appeal today. I would note that we have copies of all correspondence and supporting documentation on the appeal. I would ask that if there are other members of the public in attendance that have not made themselves known, to do so now. So I would first ask the county staff to introduce themselves by name, and then the appellant's side and any other members of the public or guests.
I'm Hayden Cotting with the County Attorney's Office.
Jay Riott, Fairfax County Building Official.
Investigator Emmanuel Felipe with the Department of Code Compliance. Richard Grace with Land Development Services, the liaison to the board.
James Anjum, Acting Building Inspection Chief.
Dan Wilhelm, Deputy Building Official.
Anybody else from the county? Carla has already introduced herself. Okay, I'll let the appellant and their guests or participants.
Yes, good morning, Mr. Chairman, members of the Board of Building Code Appeals. My name is Gifford Hampshire. I'm with the law firm of Blankenship and Keith here in Fairfax, and I represent the appellant, DJ Silberman LLC. And with me today is the representative of that limited liability company, Mr. David Silberman, and you will see him as a guest in your screen. Also with me today is his consultant, Mr. Ron Moyers, who is not on screen, but is sharing a screen with Mr. Silberman, who may appear from time to time. And my associate, Ian McElhaney, is here as well, who has worked on this matter.
Thank you.
And my name is Audra Gilbert. I am a court reporter hired by Blankenship and Keith.
Okay, thank you. For the appeal, both the appellant and the appellee can appeal a decision of the board to the State Technical Review Board. The application for appeal must be submitted to the board, the State Technical Review Board, within 21 days following the receipt of this board's decision on the appeal. Please note that a majority vote of the board is needed to overturn the building official's ruling. A tie vote goes in favor of the board. As chairman, I will only vote to break a tie. And there should not be a tie today, in that there, other than myself, there are 5 members of the board in attendance. The order of the meeting with respect to the appeal we will hear today is as follows. The appellant will present a 1-minute summary of the basis for their appeal of the county position or notice of violation. The county will present a 1-minute summary of the basis for their position. I kind of call these opening statements. And as chair, I'll try and at least frame the issue before the board. Then the appellant will speak and present their case, and the board will have an opportunity to ask questions of them after they've made that presentation. The county will then speak and present its case to the board, and the board will have an opportunity to ask questions after they're done. The appellant will then be given an opportunity to provide additional information in response to prior testimony, and again, followed by the county staff if they choose to provide additional information. If either party, appellant or appellee, has questions for the other party, they can direct them through the chair to the other party. After each time the appellant or the appellee speaks, I'll provide board members the opportunity to ask questions, and the appellant or the county as appropriate time to respond. Having completed opening summaries and 2 rounds of testimony and questions, I'll close the public hearing phase of the meeting, ask for a motion from the board and a second so that we can discuss the motion and on the appeal, and then we'll discuss it and vote. If in the board discussion a new issue is raised that was not discussed during the hearing, I'll feel compelled to reopen the hearing for the appellant and the county to speak solely to that issue, which is why I generally ask the board members to get their questions out before we move to get a motion and a second and discussion on the appeal. I would ask that when you're not speaking, you put your phone on mute. As county staff has already indicated, if there's background noise or other sound that's disrupting the meeting, county staff can mute all participants, who will then have to dial in *6 to be unmuted. When you'd like to speak, please indicate by saying request to speak in your name, and at least let me try and recognize you. I would now invite those on this call participating as or on behalf of the appellant we've already done this, introductions, I'm sorry. So I'm going to turn the floor over to the appellant for a 1-minute opening statement, and then I'll do the same with the county.
Thank you, Mr. Chairman, members of the board. My name again is Gifford Hampshire with Blankenship and Keith, and I represent the appellant. Our papers are in your package, and our position is that the violations are factually incorrect, because as demonstrated by the papers in the package, there was indeed a building permit that allowed the construction of the office and the mezzanine at issue that was issued in 1972, and a certificate of completion, which is set forth at Exhibit 2 to our package, that verified that the plans that the testimony will show included the office and the mezzanine were constructed in accordance with all county codes and ordinances. There's one slight caveat to that we will talk about, and that is that the bridge that connects the mezzanine over the office to another part of the building was constructed later. We don't know how much later. We think it was still a very long time. However, we have no problem with taking that down, but the violation itself concerns the construction of the office and the mezzanine over the office, and the documentation and the evidence will show that those items were constructed to a valid permit that was issued half a century ago, and that non-RUPs were issued over the years since then with those features in place. My minute has expired, but that's what the evidence will show.
Thank you. Who's presenting the county's position?
Investigator Manuel Felipe with Fairfax County Department of Code Compliance.
Good morning, Manuel. Okay, make an opening summary, if you please.
Good morning, board members and chairman. Thank you very much. I'd like to say that our position states that there's no factual permit based on the evidence submitted by the appellant of the required permits and inspections for the notice indicated on the, for the violation indicated on the notice of violation that was issued to both the tenant and the property owner. And they're required to have the inspections also as well. That's where our position stands.
Okay, so if I can summarize, and then I'll have the appellant give you all the floor again to make more detailed comments and presentations. It seems the issue really is, and the notice of violation is specific, are permits and subsequent inspections required or not? It appears the appellant's position is, with respect to the mezzanine and office, that they're not, because they've been there for some time and were permitted. And it appears that the county position is that's not the case. They were not, and that permits and inspections are required at this time. I think that's the issue before us. So I'll turn it back over to the appellant, and the floor is yours.
Thank you, Mr. Chairman. Again, my name is Gifford Hampshire, Blankenship and Keith. As I said in my opening statement, the issue here is a factual issue, we think, and there's also a legal issue here. The factual issue is, was the office and mezzanine over the office permitted or not? There's a legal issue that's set forth in our papers, and namely Virginia Code Section 15.22307, that states that where a building permit is issued based upon approved plans and the construction is done according to the approved plans, and the property owner pays taxes on those approved plans for at least 15 years, then the county or any county, including Fairfax County, can't come along half a century later and say you've got to remove the very things that were permitted and taxes were collected on for a half a century, almost. Mr. Silverman will testify in a minute. He is here. You see him in his screen. He doesn't mind me telling you he is 87 years old. He started business in Fairfax County in 1958, and he will testify about how he went from pillar to post between 58 and the early 1970s, when he found the subject property that was properly zoned I-5. He hired a builder. He secured a building permit for plans that included the office and the mezzanine, and that building permit is set forth at the application is set forth at Exhibit 3. His builder built according to those plans, including the office and the mezzanine, and the county issued a certificate of completion set forth at Exhibit 2 that certified that the building had been constructed in accordance with meeting all applicable codes and ordinances of the county. And I'm reading from Exhibit 2. That was in August, the end of August of 1973. The evidence is also going to show, and he will testify in a minute, that a non-residential use permit at Exhibit 4 was issued in December of 1972 for Silverman Truck Repair Terminal. And it's signed by the zoning administrator, Mr. Knowlton, at that time, and also signed off by the Public Utilities Department and the Fire Marshal's office. And also at Exhibit 4, you will see various other non-RUP permits that were issued over the years to subsequent business owners, first with Alexandria Transmissions, and then with Newington Car Center, and then finally with respect to the current business Commonwealth Garage in 2005. With that, I'd like to ask Mr. Silverman to answer a few questions. He's here. He is going to, because of technical issues with an echo, we're going to hope that his voice can be heard on my computer. He's at about 2 feet from me right now. So with your permission, I'd like to ask Mr. Silverman a few questions. Is that okay?
That's fine. The floor is yours.
Thank you. Mr. Silverman, would you state your name for the record?
David J. Silverman.
Can his voice be heard, Mr. Chairman?
I can hear it.
Okay.
Other board members, can you hear it?
Yes. Okay. All right. And are you the
Yes.
manager of DJ Silverman LLC?
Yes, sir.
All right. And when did you start your profession?
The business started in 1958.
Yeah. And what did you do between 1958 and the early 1970s?
Well, first, when I started the business, it was in a garage beside my house, and I was working on trucks, and the county said I couldn't do it. I couldn't, because it was residential. And then my wife had a grocery store on 236, Little River Turnpike at Prosperity Avenue. I built a shed behind the grocery store and was working on trucks there until the county said the zoning wasn't right. And then I leased a gas station at Butts Corner in Clifton, near Clifton, and worked on trucks there. And the county said, build a fence to hide them, which I did do. But meanwhile, I was looking for a piece of property that was zoned properly, and I bought the property that we're talking about now, and built the building in bought the property in 71, and I think we completed the building in late 72, I believe.
Okay. And do I understand from what you just said, you hired a builder to construct the building on the
Yes.
subject property?
Yes.
Okay. Did that builder apply for a building permit?
Yeah, of course.
All right. Did that building permit include the office and the mezzanine over the office?
Yes, it did.
And was that building permit approved?
Yes, it was.
All right. I'd like you to turn to what's marked as Exhibit 1 in your package,
Okay.
and it's been tabbed. And do you recognize that document?
Yeah.
And is that your affidavit that you signed?
Yes, it is.
All right. And is there anything that needs to be qualified about that affidavit?
Well, yeah, I wrote down that the building was built in 71 and it was built in 72.
All right. Other than that, is this affidavit accurate?
Yes.
And what happened in 1971?
I bought the property and started the building, but didn't finish it. until
Okay.
72.
You finish this. All right. Then I'd like you to look at what's marked as Exhibit 2 and ask you if you would identify that document, if you recognize that document.
Yes.
Okay. And that is a certificate of completion, is it not, that you secured in August of 1973?
Yes, I see that. Yeah.
Pardon me. Okay. Now, at the time in August of 1973, was the office and mezzanine over the office constructed?
Yes.
All right.
Part of the original building.
And was it constructed pursuant to the plans that were submitted with the building permit?
Yes, sir.
All right. And then I'd like you to turn to what's been marked as Exhibit 3. Do you recognize that document?
Yeah, yeah.
And is that your building permit application that your builder submitted?
Yes, sir.
And did the plans that went with that building permit application include plans for the office and the mezzanine over the office?
They did.
All right. And then I'd like you to turn to Exhibit 4 and ask you if you recognize that document.
Yes.
All right. And what is that? Is that the non-residential use permit that you secured in December of 1972?
Yes.
All right. At the time that you secured this non-residential use permit for Silverman Truck Repair, was the office and the mezzanine over the office in place, constructed pursuant to building permit plans?
Yes.
Yeah. All right. And then there are various other non-residential use permits. If you thumb through the rest of what's been marked as Exhibit 4, you'll see some other documents there. The first one is Alexandria Transmissions in 1988.
Mm-hmm. Yeah, I see that.
Yeah. Now, in 1988, when Alexandria Transmissions went into the building, was the office and the mezzanine over the office in place?
Yes, sir.
Okay. And then if you turn another page you'll see another non-residential use permit to Newington Car Center. And I have the same question for you. In 1997, was the office and the mezzanine over the office in place when this permit was issued?
Yes.
And then if you turn further, I think 2 more pages, you'll see a non-residential use permit to Commonwealth Garage Inc. dated 2005, September 2005. And I have the same question for you. Was the mezzanine over the office and the office in place at the time this was issued?
Yes, sir.
Okay. Have you paid taxes since 1972 to Fairfax County with the office and the mezzanine over the office in place, constructed pursuant to the building permit?
Yes, sir.
Mr. Chairman, those are all the questions I have for Mr. Silverman. And I think at this point, we will save any remaining for argument later.
Okay, that's fine.
Thank you.
I'm going to ask the board members if they have questions. George, Paige, do you have any questions for the appellant?
No, this is George. I don't have any questions. Thank you.
Mike Grinnell?
Yeah, I have one question. Has anybody pulled up those plans to show that existing mezzanine?
Mr. Grinnell, we submitted a Freedom of Information Act request, and these are the documents that we received back. We did not receive back the original plans. So as far as we know, they don't exist anymore. They may have been destroyed over the years.
Okay, thank you.
Rob Fisher, any questions?
No, sir.
Amado Fernandez?
Yeah, relative to the office and the mezzanine, is there any reference to specifically the office and the mezzanine in any of the documents that we've seen thus far? Where it specifically refers to an office and a mezzanine. I mean, the references I'm finding are 4,200 square feet of floor area on the first floor of the building located at Hart Avenue. So I'm looking for something that specifically talks about office and mezzanine. Is that available?
We have, as I answered to Mr. Grinnell, Mr. Fernandez, we have the sum total of what we received back from a Freedom of Information Act request from the county. Because of the age of the documents, we don't have the plans, which presumably would show the office and the mezzanine as part of them. Unfortunately, we don't have those because as far as we know, they don't exist. And the documents you see here certainly don't refer specifically to the office and the mezzanine. What you have, though, is Mr. Silverman's testimony, who is mentally competent, as you can see, and recalls that the plans did include the office and the mezzanine.
Okay. Thank you.
Wayne Bryant?
No questions at this time.
I have one. I noticed in the photographs that have been recently taken that it looks like there's a gas furnace / HVAC system that's located in the mezzanine. Is that system, was there a system up there to provide heating and air conditioning and the associated electrical and gas connections? Did something exist up there back in 1980, 1985, 1990, 1995? Or is the installation of an HVAC or mechanical system up there right now brand new, and there's never, ever been an HVAC system up there?
I'll ask Mr. Silverman to answer. Did you understand the question, Mr. Silverman?
Yes, and I have not been in the building but about 2 times since I leased it out, and it wasn't there originally, and it wasn't there when Alexandria Transmission took over. Now, anything after that, I don't know.
Right. And I should say, Mr. Chairman and members of the board, Our appeal does not concern the gas issue or the electrical issue. We have no problems with doing that. In fact, we're working on that now. Nor do we have any issue with the bridge over that connects the mezzanine over the office to another part of the building. We're certainly willing to take that out. Our appeal concerns only the office and the mezzanine over the office that was part of the plans.
I understand. Thank you. And thanks for that clarification. And the reason I asked the question is with respect to, among other things, fire safety, the fire resistance rating of certain construction assemblies is acceptable. And then conditions can change if, for instance, you put in gas equipment, electrical equipment, things of that nature. Would be no different. Well, anyway, that can change the conditions of use and situation from what was originally permitted. So that's the reason I asked the question. Okay, I'm going to turn it over to the county and Manuel. Go ahead, the floor is yours, and anybody else that you would care to have speak on behalf of the county.
Investigator Manuel Felipe with Department of Code Compliance. Thank you very much, board members and everybody here listening to the appeal. I'd like to say that first I received this case based from another investigator that was retiring, and based because he was retiring, I actually started the case all over again to give the appellant an opportunity to come forward and apply for the permits and inspections required. The notice was issued back on May 5th, 2021, and I performed an inspection on March 31st, 2021. And based on the inspection, I noticed that there was no permits issued for this. Based on the testimony of the appellant on his own exhibit, which the county also has, indicating there is no mention of any offices or any mezzanine. If you look at the Exhibit 3, which they stated that they had a mezzanine, in the section which is marked number of stories, it is clearly one story. It is not a story and a half. It is not a story or above. It's not no stairs indicating to the description. It's just a truck repair terminal. That's basically what the application for the permit was for that time. And the appellant also is correct in what's saying the plans are destroyed after 3 years. The county does not keep plans after 3 years. However, the plans in this case, most homeowners or business owners keep plans for this same purposes. In this case, we only have the testimony of the appellant's client, who actually indicated that he built this building in 1971. His own affidavit indicated that he built it in 1971 and acquired a permit in 1971. When you do a work, the first thing you do is get a permit, then you do the work, and then you get inspections, and then you get finalized. Well, if the permit was issued in 1971, how was the building finalized in 1973? He did testify that he made a mistake and listed that his affidavit was wrong by 1971 to 1972. However, the permit and inspection is clear that it was issued for a truck repair terminal, and it was only issued for one story. And I also have a question for Mr. Silverman, if I may ask. I can't hear you.
Go ahead. I'm sorry, I was muted. Go ahead and ask a question through me. I'll decide.
Mr. Silverman, how many bathrooms do you have in that location?
Go ahead, Mr. Silverman.
You're speaking to this mic over here, Mr. Silverman.
What did you have?
How many bathrooms do you have?
Originally, there was 2.
That's correct. Originally, there was 2. That's what states on the permit. But the permit actually showed that there's 2 bathrooms. Right now, there's only 1 bathroom in the place. So you see, alterations was done after this permit was issued. This permit is clear that there's 2 bathrooms. It's clear that it's 1 building. It's clear that it's 17,000, what is it? Building height, sorry, 17 feet, 44. And it's clear that it's cost about $70,000 to build. Back then, I don't know the cost, but all I know is that based on the evidence that they are actually surrendering themselves, it is clear that they don't have a permit for the stairs, for the mezzanine, for the mezzanine bridge, for the description that's on the notice of violation. And the exhibit 4 is only for, that's a zoning apparatus, which gives permission for a business to do work in the county of Fairfax. So every time a tenant changes, they're required to get their own which is called non-residential use permit. And those are on his exhibit. If you go to the picture that I have on all the way in the back, bear with me because I have to also change my screen here so I can see it. If you look to the picture dated 5/5, can everybody see that picture? May 5th, 2021, can anybody see that? Hello? Can anybody hear me?
Yeah.
We hear you. I'm not seeing that picture.
The picture is dated 5/5, is on the package, is all the way towards the very end. Just before the permits.
Looks like it's page 50 of the PDF.
Yes, yes.
Thank you. So can everybody see the picture with the exit sign?
Yeah, this is George. I can see it.
Thank you. So this is alterations that was done to that space where the office is. Clearly there was marked, that's the original exit sign, which was probably there from 1972. I'm not debating the fact that there was not an office there. Clearly there was an office there, or some kind of small room. I don't know what happened in 1972. I was not there in 1972. All I know is that there's alteration that was completely after the permits was issued. Whether it be 1 day after, 2 days after the final inspection has been approved, I don't know. I just know that there was no permit on there. This used to be an exit, which changed the apparatus of the office. And if you go to the picture before that, you see the bridge, which should be page 49, if you said that was page 50, right?
Mm-hmm.
You see the bridge that is connected to the mezzanine, which is part of the mezzanine. And that's also on the notice of violation. And you go further back, you see the furnace, that's a gas appliance furnace. Anytime you install a gas equipment, you're required to have a building permit or mechanical permit, which in this case, they actually obtained a mechanical permit for a gas boiler back in 1988. But we're not talking about these permits. We're talking about the permits required for these violation that's noted on the notice of violation. We're not talking about the permit for the furnace that's hanged in the ceiling. If you look at the other picture, which is, I believe, is page 47, where there's a furnace hanging from the ceiling, that was approved, not the furnace that was sitting on the mezzanine level. And by the way, there's 2 furnaces sitting on the mezzanine level. They're side by side. One is to the right and one is to the left with the yellow gas line, see it. And then the third one that you see is on the ceiling, mounted from the ceiling. Well, when this was a truck repair, this is a truck repair, how would they get any type of trucks through the buildings, making turns in an area with a mezzanine or bridge or any obstruction that's constructed above? Now is a car repair. So clearly they built this bridge. If you go to picture, let me see, picture of the bridge. The bridge on, I think it's page 40, 42 or 40. Can anybody see the bridge over the mezzanine area?
Yes.
Okay, so clearly.
Yes, it's on 43, something, 43 and 49.
Thank you, because I can't see the numbers on here, but thank you very much, whoever said that. But clearly a vehicle could pass under here, motorcycle could pass under here, but a truck would never be able to pass under here. So maybe the space that was originally above the office or whatever room that was there was only for storage, or maybe had the mechanical, the water heater or something like that on there. But it was never designed as a mezzanine. It was never supposed to be constructed for storage area of gas equipment over the bridge that you saw on the previous page. So basically, the only thing what we're saying is they have to get a permit required for the mezzanine and everything that's noted on the notice of violation. And then you have the office, which shows the new granite that's installed on there, and new flooring, and all that is required to have a permit, because you have changed layout. You have and that's required a building plan to show the new layout, because if there's a fire and the fire department knows that there used to be an exit there, people don't know where they're gonna go out if there's exit sign is on the other side. That's the reason why the whole purpose of this is just for the safety aspect of it, just to make sure that everything's done correctly and everything passes inspection based on the person who's installed it. My last comment is going to say that, well, I'll save this comment for the end. I think I'm okay.
Okay.
Thank you, board members.
Is there anybody else from the county, Manuel, that's going to say anything? Manuel?
I don't know if
Hayden Cotting with the county attorney's office. I have a quick comment, if that's
Certainly.
all right. Yeah, in regard to the 15.22307 argument about taxes being paid for 15 years, that's regarding zoning approval. And I'll quote from 15.22307 that excuse me, let me find it. That a zoning ordinance may provide that such building or structure be brought into compliance with the uniform statewide building code. So just no matter what happens with the zoning approval, you still have to apply with the USBC according to that section of the Virginia code. And then if you look in the zoning ordinance under compliance with other applicable regulations and standards, it says that, quote, no structure is allowed if it is precluded by any provision of the county code or is subject to any applicable requirements of the USBC that conflict with the zoning approval. So even if you got the exemption under the 15 years for to be non-conforming under 15.22307, you still have to comply with the USBC.
Thank you. Okay, I'm going to ask board members. George, do you have any questions for the county?
Yeah, this is George Page. I have a question for Mr. Philippe. Are you there, Manuel?
Yes, sir, George.
Okay, so I'm trying to get my head around just what the county's issue here is. The paperwork that came to us was all about a mezzanine and an office that were created without a permit. And yet all we've talked about is the fact they've removed a bathroom, they've covered an exit, they built a bridge, they renovated an office. How do I how do I reconcile those two things? What you guys came in with your paperwork saying, they built an office in a mezzanine without a permit, but all we've talked about and all your pictures show just changes. Go ahead.
The notice of violation actually indicates that the floor plan to the warehouse was altered by the construction of the office space with a mezzanine. So the floor plan, so whenever, for commercial installation of permits, they're required to show a plan. So therefore, the floor plan was altered. That's what it indicates there. I brought up the fact of the bathroom based on the testimony that the permits was issued and from 1972.
But I can see that the office has been renovated, but if I look at the mezzanine, that doesn't look like something that was built yesterday.
That's correct. You're absolutely correct. The mezzanine was not built yesterday or sometime, probably it was built probably back in the 70s or probably in the 80s. I have no idea when it was built. I know it wasn't built with the permits that was approved based on what the permits is indicating.
What is Exhibit 2 all about then? That says, you know, you've completed your construction.
It makes no reference.
Let me go back to Let me go back to Exhibit 2.
Yes, that's correct. Exhibit 2 is completion, but that's only of what they have seen. With stating right here that that mezzanine, that office was not remodeled the way it is back when it was done back in 1973.
Well,
that's what we're stating here.
Well, and what was completed then? What was this all about?
A truck repair terminal was completed. The building was completed as a truck repair warehouse terminal. That's what was completed with two bathrooms and what else? I don't know. That's what was completed.
Okay, for $70,000 according to Exhibit 3.
Yes, with cinder block and steel roof. I don't know. That's what it is.
Okay. I'll let other members talk. Thank you.
Mike Grinnell, questions?
George, I feel your pain as I'm trying to wrap my head around this too, and we'll get more to that later. Inspector Felipe, I had one question, and it's on that page 50 that you had drawn our attention to with the exit sign. And yes, if I'm looking at this correctly, there is an older exit sign, who knows when it was put in, and it appears that there used to be a door there that was since, and I assume that door was an exit door that has been plastered over with some sort of wall system, whether it be drywall or whatever else. But am I correct in that assessment?
That's correct.
Okay, thank you. That's all I have.
Rob Fisher.
I guess the only thing I would, just to sort of summarize, I think based on George, the questions George asked, Mr. Felipe, it sounds like you've got, or what we're maintaining is that there was a permit that was issued to sort of initially create this truck repair center. And that was finalized, that was all done appropriately somewhere between 1973 and today. The mezzanine was completed and that was not permitted. Is that pretty much what this is about, along with the additional heating unit? Is that a fair assessment of what your violation is about?
Yes, sir, Mr. Rob, that is correct. Is the only thing we're addressing here is what's on the notice of violation, which is the mezzanine, the floor plan, the electrical, and the furnace.
And Mr. Felipe, your violation does not necessarily mean it has to be torn out. It just means it has to be permitted and inspected.
It has. I always let them know that they have two options. Those are the two options that they have.
I don't think we caught all that, Manuel. Can you repeat the two options?
So option one is to bring the violation into today's current code by getting the proper permits and inspections, passing it because it was never approved. or option 2 is to remove the violation, which is also noted under notice of violation. The same 2 options I just addressed.
Okay, I'm good.
Amato, do you have any questions?
The notice that was given to the appellant, it indicated that compliance with
And hang on, somebody's coming through with background noise. Okay.
All right.
Go ahead, Amato.
Much better. So the just kind of to reiterate the point that Mike was making, and I think George started to make, but there's a violation. Work was done with a permit back in 72, 73. It was permitted. It was approved. Non-RUP was issued, but the criteria that was specified on the permit back then did not address the issues that are being found today, i.e. the office and the mezzanine is one of them. They talk about an electric panel. They talk about a gas-fired furnace, although the original permit did allow for an oil-fired furnace. At least it was checked in the box as far as what heating was installed back then. And it had 2 baths, which means if there's only 1 bath now, there's been a change made since that point in time was issued. So is what's being asked is to bring the current construction to meet current standards, current code issues, and modify the original permit so that the permit now reflects what's in place today. Is that the intent? Am I understanding that? Or tear it out, I guess. But you can't tear it out, because if you're willing to tear it out, since the original permit has 2 bathrooms, you'd have to actually build a bathroom in order to be able to meet the original design, the original criteria. So that doesn't make any sense. So I'm assuming it's being asked to bring it up to code.
Yes, Investigator Manuel Felipe with the Department of Code Compliance. Yes, Amato, that's correct. The violation is being asked to bring it up to today's current code or to remove the violation. If they decide to bring it up to today's current code, they have to draw a plan. That plan will stay on record indicating that now there's 1 bathroom, not 2 bathrooms. So they do not have to install another bathroom. If they wish to, they could do that, but they would need to show a plan. And again, that plan would be on file for 3 years or however long the county decides to keep that. They're only required to keep it for 3 years, but usually owners keep it for 10 years or 20 years.
Okay, thank you.
You're welcome.
Wayne, do you have any questions?
Yes, I do.
Okay.
And it seems like this is all related to the mezzanine. It seems that the appellant has stated that the other items would be taken care of, including removing the little walkway and those sorts of things. It just really comes down to, it seems to me, correct me if I'm wrong, but it seems to me it's coming down to, this mezzanine and the structure of this mezzanine and whether it was built under the original construction or not. And I guess the question is, Mr. Felipe, do you know what, like back in the 1970s in the permitting process, whether they would have included, obviously it's a 1-story building with a small mezzanine. Do you know if they would have included that when they wrote the permit?
Yes, I had research permit from 1950 that I have researched, and they had the description of the permits indicating what it is. Some permits have clear description, some permits do not have clear description. But when it comes down to a commercial plan, commercial permits, they have to have plans associated with it in order to be more identifiable if it's not clearly described in the description. So it's basically the same thing as well, I'll wait that for another time. But
Well-
yes, to answer your question, yes, it would be on there if it is a mezzanine. Mezzanines are required certain height, which this does not have. It requires certain apparatus, which this did not have back in 1972, in 1973 when it was approved.
But it seems to me without the building drawings, you really have, you just got done telling me that, you know, sometimes the description is on the permit and sometimes it's not, but the drawings show it. So it would seem to me it's hard for you to, and the county to state that this was not part of the original construction. It certainly looks old. It's hard for me to determine when it was built or that it wasn't part of that without the drawings from the original project.
Well, the codes really changed for the benefit and safety purposes of the.
But that's not part of this discussion.
Well, you opened the door to answer the question about why the description is on there. Okay, because I don't know what they put on it back in 1972, who puts what on it. All I know is that the fact of the matter, the description on this permit does not indicate the permit, the mezzanine or any other apparatus, including the bridge to the mezzanine.
Right.
Or stairs.
But you, as you just said, you don't know what they did or didn't do back in 1970s. So you don't know if they would have said this is a one-story building and there's a mezzanine and they show, well, it's on the drawings. So, you know, we know that it's a mezzanine. So I'm having a hard time with the county going back 50 years and stating based on a building permit that is very rough, certainly not to the level that you guys do now, and stating what was implied or what was written on there. I'm having a hard time with that. Can you provide any clarification on how you got to the point where you knew that that wasn't, other than a one-story building that you yourself say, you know, we don't really know what they wrote down?
No, I didn't say that we don't know what they wrote down. I said we don't know how they describe the description. So how they describe the description of what they write down on there is what's different. So in this case, the building permit indicates that is a truck repair terminal. That's what it indicates.
Right, which could have a mezzanine as part of the drawings.
No, it would say truck repair terminal, 1.5 stories, 2 stories with a mezzanine.
Okay.
When you
Wayne, let me jump in.
Okay, sorry.
Can I jump in, David?
Is this a motto?
This is a motto.
Yeah, go ahead.
Yeah, the one clarification I want to make although it doesn't specifically say anything about a mezzanine, but you keep referring to a mezzanine as a 2nd story or 1.5 stories. And by definition, just so we're all clear, a mezzanine is part of the ground floor. It is not another story. All right. This is now code definition. So they didn't mention that they were building a mezzanine. I concur with that. But to imply that because they didn't talk about a 2nd floor, there's no mezzanine, that's also not right. Okay. So that was all.
Okay, Wayne, were you done?
I am done. Thank you.
Okay, I have one question. Manuel, if it's page 45 of the PDF, it's the March 31st picture of the Goodman furnace that's got the yellow gas pipe to the left and some boxes to the right, and what appears to be the electrical box that's hung on some pegboard. Are you with me?
Yeah.
Yes, I'm with you.
If I look at that and then go up, so now I'm going back, I see the electrical outlet or the electrical box. I see boxes, and the furnace, the first furnace is to the left of this, and then I see tires and a Christmas tree, etc. And then if I go up one more, I kind of get a whole picture of where that is. I see the tires up in the mezzanine on the left. Then as I go to the right along the railing, I see the boxes. And then to the far right, I see that yellow gas line and where it enters between what I think are two furnaces. So my question is, looking at that, whether there was a mezzanine in the original drawings or not, the fact is, if you, in getting a mechanical, gas, electrical permit to approve the installation of the electrical wiring and panel up there that was on the pegboard, and the installation of the gas furnaces and line up there, will those permits and your inspections of those items, which the appellant has indicated they're going to apply to, will they address what look to me like some potential fire problems related to storage and so on? Whether the mezzanine is a mezzanine or a story or was on the plans 50 years ago or not, will their permits and your inspection take care of what appear to be some safety concerns up in that area?
Yes, to answer your question, yes, that will take care of once the inspection is performed. They'll note it that the tires cannot be stored there, and the electrical cannot be installed on the pegboard the way it is at that point, and the gas. All that will be noted on there once they get the permits required in the inspection. And one picture I did not put on there, which that was my fault. And I do have the picture in case it's okay to add it on there where everybody could see it on my screen. I could share the screen.
If you can share your screen, then go ahead.
Okay, there's the picture with the stairs. Hold on one second. Thank you very much. I appreciate it. Okay.
I don't think we're seeing anything yet.
You don't see? Oh, hold
No.
on a second. Hold on a second. Okay, I'm going to share my screen now. Can you see the screen?
Yes.
This picture here that shows the stairs, where the stairs goes up, and to the left is can I make it bigger, or can everybody see it fine like that?
Couldn't see it fine.
That's fine.
Okay, so this is the stairs behind the office. The bathroom is in this location, and up the stairs to the left is where the two gas furnace sitting on top of the mezzanine area. And then to the right is the bridge where all the tires and the Christmas tree is located.
Okay. That's the only question I had, and I think it was answered. Okay, I'm gonna go ahead, Manuel.
I said thank you.
Oh, you're welcome. Okay, we've gone through one round of input, so now I'm going to give the appellant an opportunity to provide any rebuttal that they'd like and to summarize. And in the interest of time, if you've already said something, there's probably no need to restate it unless you want to do it very briefly.
Thank you, Mr. Chairman. Gifford Hampshire,
Sure.
for the appellant. I just like to start by pointing out, as several of the board members have, that we really do need to focus on what the violation is. And if you turn to your package and you look first at the violation, you see the first two bullets, which are at issue here. The other ones we're going to take care of. It says that a mezzanine was constructed over an office, etc., and which included a bunch of stuff. And then the second one says a floor plan to the warehouse was altered by, not by anything under the sun, but by the construction of office space with a mezzanine. So we really are, as Mr. Bryant said, we really are talking only about the mezzanine over the office and the office. And so we need to focus on what is the evidence about those two things. The evidence that you've heard is the testimony of Mr. Silberman, who was there on the ground at the time in half a century ago when he built this building. Unfortunately, we do not have the plans. We tried to get the plans. The county said they don't exist. So we're limited for this hearing, and you're required to make a determination based upon the evidence presented to what is the evidence about whether those plans included the office and the mezzanine. And the evidence is uncontradicted that it included, the plans included the office and the mezzanine. Mr. Felipe's testimony in response to Mr. Bryant's questions, and also in response to Mr. Page's questions, revealed, as would be expected, and it's certainly understandable, that we here sitting in the year 2021 really cannot say what the practice was in 1972. And certainly you cannot say definitely that in every single case, and Mr. Felipe didn't testify to this, that in every single case, a building permit would have stated specifically, explicitly, that there was an office and a mezzanine as part of the plans. They would have just referred, it could have just as easily referred to the plans. And I think Mr. Felipe even testified to this effect, that because there is no sort of uniformity on the permit application itself, you have to look at the plans. Unfortunately, we don't have the plans. So the preponderance of the evidence that you're required to follow is the testimony of Mr. Silberman that the plans included the office and the mezzanine. So we think that that is what the board is required to follow. With respect to the testimony about the truck repair terminal, I'd like to ask Mr. Silberman just a couple questions about that, and also about the bathrooms. Although I will note that I don't think the answer really matters to the issue at hand, and that is, was the office and was the mezzanine part of the plans that was approved in 1972 or not? But I'd just like to clarify, if I might, Mr. Silberman, is a truck able to drive into the garage today? You were there this morning, were you not?
The truck wouldn't, not enough room.
Is that right?
Because of the equipment they have in there.
Yeah.
It's set up for auto.
Oh, because it's set up for automobiles right now?
Because it's got the lifts and things.
All right.
I didn't have any lifts in it.
All right. But if the lifts weren't there, could a truck drive in there?
Yeah.
Is that right?
They could drive a tractor trailer through all three bays.
All right. So as you heard, the answer, Mr. Chairman and members of the board, is that the space has been retrofitted for lifts for cars, but for that, the structure, the mezzanine, allows the passage of a truck in there for repair. And Mr. Silberman, how many bathrooms are in there now?
There's two.
2 bathrooms? All right. So you've heard his testimony, is there are 2 bathrooms, just as there were before. Now, the fact that there might be some renovation that has happened recently, again, we go back to the violation. The violation has nothing, does not complain about renovation. What the violation complains about is the construction of a mezzanine in office without a permit. And that's what's at issue here. And the preponderance of the evidence is that there was in fact, all evidence, all uncontradicted evidence is that there was a building permit for the construction of an office and a mezzanine over the office. The remainder of the violation we're going to take care of. With respect to 15.22307, I will take issue with my friend Mr. Cotting's construction just a little bit. If you look at that code section, it does say that such building, and we have this in our appeal paper, such building or structure shall be non-conforming, and a zoning ordinance may provide that such building or structure may be brought into compliance with the Uniform Statewide Building Code. Key provision though, comma, provided that to do so shall not affect the non-conforming status of the structure, building or structure. And then further on down in the code section, it says that a zoning ordinance may provide that the structure is not conforming, but shall not provide that such structure is illegal and subject to removal solely due to such nonconformity. So the Hobson's choice that is presented to Mr. Silverman of securing a permit for something that he probably can't get permitted under today's codes or tearing it down is in direct contradiction to this code section. With that, I think that I've made my point, Mr. Chairman, and members of the board, and I'm ready to answer any questions.
Okay, George,
No, I don't have any more questions. Thank you.
Mike,
No questions.
Rob Fisher,
No.
Amato,
Yeah, I'm still trying to get my arms wrapped around, or my head wrapped around the issue. The appeal is indicating that per the recollection of Mr. Silverman, is that the mezzanine and the office were part of the original permit application. However, changes have been made to both apparently the office and possibly the mezzanine since that original permit was done, which, as far as I can tell, there is no permit for those changes. For example, the closing off a door that had an exit sign over it. We don't know when that was done or how that affected the original permit criteria. So are you only asking for relief on the original design, on the original permit? So anything that has happened since then has to be documented, permitted, and validated?
Yes, sir. Well, what we're doing is appealing the violation that was issued. So the violation that was issued, if you look at it, is limited to construction, original construction of an office and a mezzanine without.
Okay. Only original construction of a mezzanine in an office. That's all you're appealing, not any subsequent any changes that have occurred, which may or may not be compliant with code.
And I would say, correct. And I would say that the county, if it has an issue with those, needs to issue a violation and give us an opportunity to appeal that if we want to. We need to look at it. But we're limited, and I suggested the board is limited to what the violation states and so we're appealing that. And the violation is concerning original construction without a permit.
And you're only appealing two of the first two bullet points, not all bullet points.
Correct.
There are 4 bullet points on the violation notice. So your appeal is limited to the first 2 bullet points of original construction.
Correct.
Okay, fine. Thank you.
Thank you.
okay, and sorry, Wayne, any questions?
No questions. Thank you.
Okay. And I don't have any either. So I'll turn the floor over to Manuel. Any final comments or rebuttal?
Investigator Manuel Felipe. Thank you very much, board members and chairman, for the opportunity to be able to speak on behalf of this. The bottom line of this, what we're talking about, is the safety aspects of it. The whole reason codes are designed for safety of the occupants, the business, and anybody who enters that place, and any place, in fact. The building permit was not issued. The alteration was made. We already identified, and the appellant also stated that Mr. Silverman also indicated on his testimony that alterations was done. Alterations was done to the bathrooms or the location. Mr. Silverman also testified first when I asked the question, how many bathrooms there was. I specifically asked the question, how many bathrooms there was. I only saw one bathroom. Mr. Silverman indicated that there was one, and now the appellant stated and asked the same question again and stated that now there's two bathrooms based on the permit that was issued. The only thing that they are disputing is the first two bullet items. The two bullet items which clearly indicated that it's not part of the permit, the alterations to the space by the floor plans that was changed, and the construction of the space by adding the furnace and changing the floor layout. When that's the only two things that he's disputing, and based on the pictures and based on the notice, it's clear that alteration was done. So therefore, I asked the board to uphold this decision and getting them to apply for the required permits. For the safety aspects of it, gas, like Chairman David indicated, when you have gas issues, you know, you have combustibles material, or in different ways. All it is a remedy for disaster. And nobody here is God, and we don't know when something could happen. We only know if something happens after it happens. And we're just trying to keep everybody safe by getting the permits and inspections required. We don't want no casualties. We don't want no problems with people working there, smelling the carbon monoxide if it's not installed correctly. All these problems are something that could happen, but we don't know when it will happen, or we don't know, you know. But all we're saying is that the requirements for a permit should be in place, just like what I wanted to say also in relating to people driving. We all drive a vehicle, and we all have to get a driver's license to drive a vehicle. And you also have to get a vehicle registration. Now, some people, they get a driver's license to drive vehicles down the street, and they don't register their vehicle until they get into an accident. There have been people that drive for years and never had a driver's license until they get pulled over and find out, oh, we didn't know we needed a driver's license. But the bottom line of all of these permits and licensings and inspections is for the safety aspects. That's the only thing I'd like to say. Thank you very much.
Okay. George, any questions?
No, I don't have any questions, David. Thank you.
Mike Grinnell?
None.
Rob Fisher?
No, sir.
Amado Fernandez?
In the material that we were sent, at the very end, starting with page 51, there is a list of records of either violations or things that were raised that don't specific, you know, that so there's a, if you go to building permit, yeah, on item 9 and item 10 on that list, it talks about install mechanical equipment, mechanical permit approved in 1988. So in 1988, there was work done on this facility, some type of work. Mechanical equipment was replaced, installed and replaced. And do we have any idea what that was? Whether it's anything referencing what the violation is referring to? Because it doesn't indicate that it's a gas unit. It just indicates that it replaced mechanical. Is this all that there is relative to this issue from the county records? And I'm asking the county that question.
Thank you, Manuel Felipe, Investigator Manuel Felipe with Department of Code Compliance. Yes, to answer the question, it is in reference to it is in reference to a gas appliance. If I share my screen again, that same notice shows the boiler heating equipment was for that permit. So the permit description is for general is when they show as install mechanical equipment. And then in the bottom, where it shows you fee calculation, it shows what type of equipment was installed. And in this case, it was a boiler, water heater, heating equipment for that particular unit.
I see. Okay.
Which, by the way, they do not have that no more.
Okay, so that was further changed at some later point in time.
That's correct.
Okay. All right. Thank you.
Wayne, any questions?
No, no questions.
Manuel, I guess I have one. Again, I think they've stated they're getting the mechanical and electrical permits, which means you'll do an inspection of those items. In doing that inspection, does the code then trigger your looking at, say, issues like fire suppression, fire separation, egress stairs, clearances, combustible storage? In other words, when I get the mechanical, gas, electrical, other than just looking at the equipment, is that going to give you the opportunity to look at the pegboard and some of the combustibles up there, and so on and so forth? Mezzanine and office might stay where they are in terms of floor area and things that have been discussed. But in terms of getting to the safety, to the mechanical, gas, and electrical permits and inspections, will that give you enough opportunity to make sure that what we've looked at is safe?
To answer your question, I would need advice of Amjan or Jay in reference to having a plan drawn, because a commercial application could actually get a building, a mechanical permit or electrical permit without having any plans. And if you don't have no plans, that's not going to bring up the safety aspects of what's happening here. That's only going to provide them with the permit, but it's not going to provide them to look for further issue as far as the safety aspects is concerned, with the tires being stored there, the height, no fire suppression systems or any combustible material.
Okay, thank you.
You're welcome.
Okay, there being no other questions, I'm going to close the public hearing phase, and I'm going to ask for a motion to either side with the appellant and approve the appeal, or with the county and deny the appeal. The issue being applying for the necessary permits. I think the applicant, the appellant, has already indicated that their issue is with the first two bullets. They are going to apply for, have applied for permits for electrical and gas and mechanical. Do I have a motion to approve or disapprove the appeal?
I'll make a motion to approve the appeal.
Second, Mike Grinnell.
Okay, discussion.
Yeah, I'd like to offer, let's talk a little bit about the appeal. Specifically talks about there's more than just the original. I mean, what I've heard is that the appeal is to validate the original construction. There has been work done in that location since then. Clearly, the main office with the granite countertop was not installed in 1972 under any circumstance. So therefore, things have been done there without any apparent updated records or permits.
Yeah.
So if we're appealing the original if you're limiting the approval of the appeal to the original construction of the mezzanine in the office, then I can understand that. If you're approving the appeals generally to include everything, then I think it needs to be clarified. It needs to be narrowed.
My thought on this was, Amato, that we would uphold the appeal, and if the county wanted to go back after the items 3 and 4, which they should, they can resubmit just with those items.
Yeah, this is George Page. I agree with that. We have to deal with the document in front of us, and half of it is not right.
So the way I wrap my head around this, and I think we're all kind of on the same page, right now, the way that violation is written is it says that there were alterations made by adding the office space and the mezzanine. So that just comes down to the question of, do you think it's original or not? Now, that said, there are other violations that we all kind of see there. So for instance, on page 50, that exit door, that's no longer an exit. Clear violation, something happened, you know, and that's an issue, but that's a violation. And I think Mr. Hampshire kind of touched on that. That's a violation that hasn't been issued yet, and it's probably going to come and should come. But for now, we're just looking at the appeal, which says we contend that this office and mezzanine space was part of the original. And then you kind of look at what we've got. You know, we've got Mr. Silberman in this case who says, I was there, I saw it, I did it. You know, and then Mr. Felipe who says, well, the paperwork's not necessarily in order. We destroyed the plans and it could have been built in the 70s. So that's just kind of the choice. But there are future violations to come, and this isn't over, but it's a simple kind of on our case. That's it.
Yeah, this is George again. Look, the county they can issue another notice of violation, but the one in front of us is the one we have to deal with. And I think what I'm hearing is we're all in agreement that, you know, the mezzanine and the office might not be issues at all.
I just had one observation. There's 4 bullets, you know, that we've talked about. In approving the appeal, are we indirectly then approving that they don't need the electrical, gas, or mechanical permits? So, no. You know, I would hate to see us make a mistake and then all of a sudden, oh, well, we approved the appeal, we don't need to get permits for that. So a consideration might be to split this and say approve the appeal with respect to you know, the mezzanine and office existence, and then, you know, deny the appeal with respect to electrical, gas, or mechanical.
So in this case, they've already dealt with that. Second paragraph, page 4. While the owner plans to, and this is from the lawyers, while the owner plans to comply with the violation notice in respect to electrical and gas appliances issues identified, it hereby appeals the determinations of the notice of violation with respect to the mezzanine and office.
Okay.
That was part of the original construction that was validated by a building permit and certificate, blah, blah, blah. So they've already said, we messed up here. The only thing they haven't truly said, and this is going to come on the future violations, is, oh, by the way, we did close that exit door off, and this is a violation. But that's coming downstream of our meeting today.
Okay.
David, this is George. You know, if they can always issue another notice of violation, we don't have to piecemeal this. The appeal is that this notice of violation is wrong.
Yep.
And we're agreeing with them.
Okay. Any other discussion?
No.
Okay. So we have a motion and a second to approve the appeal. George?
I approve the appeal.
So your vote is yes?
Yes.
On the motion? Mike Grinnell?
Yes.
Yes. Rob Fisher?
No.
Okay. Amato Fernandez?
I'll follow Mike's lead. I'll say yes.
Okay. And Wayne Bryant?
Yes.
Yes. And chairman not voting. So the appeal is approved with a vote of 4-1, chairman not voting. Okay. Thank you, everyone, for your time and attention and consideration. I'll call the meeting adjourned, and I'll get this written up later today and get it to Carla, and it will get out to everybody.
Thank you very much.
Okay?
Good, thank you.
Thanks.
Thank you.
Have a good day.
Thanks, guys.
Thank you. Thank you
Take
very
care.
much.
Bye.